Welcome back. It's still Tuesday and this is still the House Committee on General and Housing, and we are now going to spend time going through key issues with respect to 772, which is residential rental reform. So what I'm going to plan to do is, as we work down the pages that I gave you, is just frame the issue, remind you about some of the testimony and then have discussion. So first is a bunch of notices. These are generally not notices inside of litigation. This is before litigation. This is rental agreement. Remember, there's two parts to the statute: rental agreement and then ejectment. This is the rental agreement. And so first of all, there's how you give notice generally. And the current law is delivered or mailed. 772 adds posting on the door and email. I just should alert you that a number of the letters and comments we've gotten from both the nonprofit and the for-profit community of landlords is that one problem is that it's sometimes hard or impossible to give notice, and that people actually avoid being notified one way or another. And that's part of the delay. As you remember, one of the major issues for the landlord side and the tenant side on opposite views is how long the whole process takes. And so what you see here in these notice provisions are attempts under various provisions, various bills to try to shorten these. But the first is, what about giving notice that's generally like you're not, whether it's notice that I'm not going to renew your lease, or it's notice that you're not paying your rent, or notice that I'm going to convert condominiums, et cetera. What is that notice? And 772 adds posting on the door and email. Currently, it's delivered or mailed. Did I put it accurately? Okay, Debbie.
Wondering if we could include a certificate of mailing.
Like, what do you mean?
Okay, a certificate of mailing, you can get them at the post office,
Do you mean
but it just,
return requested or
no, it's not
certified mail? That
It's not certified mail with return receipt. It's a certificate of mailing, and you put, their address, and the post office puts a stamp on it, like this was mailed this
it proves
day.
that you've mailed it.
And it's just, it's proof that you've mailed it.
Isn't there a presumption?
So one thing I was gonna, for the record, Cameron Wood, Office of Legislative Counsel, one thing I was going to comment, it was brought up in some of the testimony you heard last week. Currently, the statutory language says actual notice means receipt of written notice and delivered or mailed. So I think there is a requirement in the statute, and I don't know exactly how courts have interpreted that, but requirement that you need to demonstrate that the individual has received it. And so that may be something you want to keep if you're moving it forward, even if you're going to add. You could, I think, approach this one or two ways.
Doesn't one of the bills have a presumption in it, the presumption of receipt?
It says that that's currently, I believe it's in statute. It says,
See, this is not a minor issue. This is important. It's the way the whole thing starts.
it's a rebuttable presumption that the notice was received 3 days after mailing is created if sending party proves that the notice was sent by first class or certified mail. And that is kept in 772, for example. But I do think if you're going to remove the word receipt of, you want to keep that rebuttable presumption and or maybe add something in where you must demonstrate it was actually mailed.
Yes, Tom, and then, well, actually, you were first, Gail.
No, he answered it.
Okay.
Oh, okay. Just so I don't assume that I know what this term means, rebuttable presumption. Just to clarify.
So if I take you to court for the ejectment action and I'm trying to demonstrate that I provided you actual notice of the termination. If I mailed it via certified mail, it creates a presumption that you received it.
Okay.
The only way you would rebut that presumption is by giving evidence to the court that you did not receive it.
You'd have to
The
have
burden would
evidence.
shift to you to demonstrate that you did not receive it versus the burden remaining on me that I ensured that you received it.
So current law, to summarize, this is important. I know this sounds really detailed, but this stuff really matters in real life. The current law provides, it sets out what notice is, and then it provides, there's a rebuttable presumption that it requires receipt, right?
Yes.
It does require receipt. But there's a rebuttable presumption of that if it's mailed, that it's received, unless something is indicated to the contrary. Is that in 772? I ought to know, but I don't.
Yes, sir.
Okay, so both 772 and general law provide that. The only thing that 772 does in an attempt to kind of modernize the situation, it actually adds specifically that it can be posting on the door or it can be emailed. But in any case, it's still the same. In other words, it has to be received, but there's a rebuttable presumption it has been received. I would assume with email, you'd know, right? Would you?
Check here.
So I think a few things to help.
I don't know.
And I was just gonna pull up the current statute, so you have it all.
You'd have to make it
Just the-
bigger.
This is just the definition of actual notice, so this isn't the termination section, so just to bring up this piece, so you have it. I mean, I think a few things that you all want to consider as you're moving it forward. First off, do you want to require in the law that the actual notice requires receipt from the tenant? That, I think, is the first thing you need to answer. That can become problematic if you keep receipt in, but you allow somebody to stick it to the door. Does that mean receipt? Do you want to expand the rebuttable presumption in the event that somebody were, sticking it on the door, et cetera? So I just think that's the first thing, is figuring out whether or not
Yes.
you want to keep that in.
Okay, yes,
So with email, I will be the first to admit that I will read an email and not necessarily respond, because I'm like, I'll see them in 10 minutes. And then someone will ask, did you get my email? Like, email is just very easy to not respond to. And so this is maybe a silly question of like, what is receipt? Because I mean, I've also sent emails and it's, return to sender, or their protections or their firewalls, like, nope, not having it.
And so that's what I mean, is if you're going to keep in something like receipt.
Yeah.
Then you may want to expand that rebuttable presumption to include when the email is sent. Because the current law is it's mailed or hand delivered. You know that it's received as someone hand delivers it. You can prove that they have it in their hand. And then it's saying, we're going to give you a rebuttable presumption if you mail it, that they get it 3 days later. So you're kind of covered. You know that there's receipt. You either hand deliver it, rebuttable presumption that you mailed it. The only way you're getting away from the rebuttable presumption is if somebody's able to demonstrate via evidence that they didn't receive it 3 days after. If you're going to expand this to include other things like email, then I think if you want to maintain this requirement of receipt, then I think you may expand the rebuttable presumption to say rebuttable presumption is when it's mailed. And then you could demonstrate that if somebody comes into court and they say, well, yeah, you mailed it and you mailed it to the wrong address, right? That would get rid of that presumption, because you can then prove that you emailed it to the wrong address. Or if you receive a email not sent automatic reply. Well, if that comes out in discovery in court, you can then point to that and say, see, I never received it. And you knew I didn't receive it because you got some sort of automatic response. The challenge with email, if you're gonna keep the words receipt, or how do you prove someone receives it?
Mhm.
So I think those two things probably go hand in hand. If you're gonna keep receipt, you may want to have some sort of rebuttable presumption that if you send it via email, it's presumed that it's received the day you sent it. Whether that is then that's a policy decision for you all, whether you think that's appropriate. If people aren't reading their emails the day that they're sent, et cetera, that's something that you all then would need to determine.
Maybe the spam.
I just had a question on, if you have it in your lease, that it's the tenant's responsibility to update you on any address change. And then, like, so you mail it to that last known address that you have as a good address. And then, like, when we get further in and maybe we're in court, and they're saying, I never received it, I changed my address.
Right.
Then if it's in the lease that they have to keep you updated, are you covered?
That is a great question that I would probably defer to people who are in court and practicing as to whether they, how the courts have interpreted that. I can just give you my experience in the Department of Labor, which is slightly different. But when we would be sending out determinations, people are in overpayment, it's for, as you all may remember, I was the director of the unemployment insurance division. When we would send out notices via mail, we had those similar requirements. It's your obligation as the claimant to update your information with us. If courts found out that individuals did not receive them because they had moved their address, et cetera, they would force us to go back to square one and we would have to start over.
Okay, so I'm gonna just throw out an option. I'm only doing this because we have so many issues. So please don't think I'm really like going to the mat. I'm just trying to get us focused. I think it's valuable to leave receipt in. I mean, we want people, we want to know as a matter of law that they had to receive it. But I think the rebuttable presumption is very important there. And that if we have the rebuttable presumption, we have to clear that. I mean, I can think of adding two things, Cameron. One would be that with email, the rebuttable presumption is created upon sending the email. And two, that with I think if it's nailed to the door, it's just deemed received. But what, I don't know, that, I'm just throwing that out.
I don't think email should be included. I think it's not in there. It's handwritten or mailed to the last known address, and I think it should just leave at that. With the technology issues, there's too many things that could go wrong with it going to spam or someone not having internet service to access their email. I mean, there's too many what ifs and unknown variables by including technology. And I think hand delivered or by mail with
Or
a
posting on the
rebuttable
door.
presumption, yeah, or posting on the door, but with like receipt with presumption, rebuttable presumption, I think is fine.
So one thing I will just comment on 772, and I apologize, we don't have the language in front of us right
Yeah.
now. Your draft, as it's introduced, does not allow just email, and I don't know if this was the reason.
What did it-
I'm thinking it required email and mailing it, so
Okay,
there was
thank
at
you.
least that two piece.
Oh, the two.
Yeah,
Yes, sir.
How do you feel about that if it's both?
if it's both
Yeah.
required, if it's required that it has to be both, then
It
that's
has to be
fine.
both. Okay,
If you have the email address.
Yeah.
Right, and they just can't say that, oh, I sent you an email and call it good.
the only thing is, do you ever have a tenant experience where tenants only give you the email? There is no mailing address.
Well,
Shouldn't, yes, I would say there are situations like that because we have addresses that don't get mail delivery.
Yeah.
So they either have to have a post office box.
Yeah, well,
And if they don't want the expense of that, then
and that's what posting on the door is for.
they're
Yeah,
posting on the
Or
door
giving
and
it to them.
email.
yeah, giving it to them. Yeah,
Yeah.
right. How do people feel about that? The status, what we're talking about is, I'll try to, well, why don't you try to frame what that,
Before I go there, you had a question.
oh,
I'm just confused. How do you prove that it was put on the door,
Somebody says, I put it on the door.
that's it.
Yeah,
Take a photo.
Yeah.
That's what the mail delivery does.
So in 772, and I'm just bringing this up because this
Yeah.
is the only bill that has these kind of expanded notice provisions in them. Any of those new methods, posting it on the door, sending it via email, also required it to be mailed.
Great.
So that, you kept that in. all
thank
those
you.
provisions.
Somebody remembers what's in my bill.
Just regular first class mail.
You would get the presumption if it was done via first class mail. So if you just send it regular mail and you don't have that first class or certified mail, you don't get the presumption. You have to go to court and prove that they received it.
Okay.
Debbie,
You can't always mail it.
Yeah.
If they don't have a mailing address.
then you gotta post it on their door.
Right, but they're saying it's always backed up with mailing, but
It says currently it is mailed to the last known address or the address provided in the residential rental agreement. So it expands it a little bit there. As long as you're required, I don't know how much this is changing practice on the ground, but in theory, based on that language, as long as you're requiring an
Does
address.
posting also require mail?
Yes.
Yeah.
On the door?
Yeah,
Yes, sir. On your draft of 772.
yeah, well, what do you think?
That's a really stupid question.
Ask away.
Hypothetically, wouldn't the last known address be that unit?
The one.
So, I think it depends on how they're asking the question.
Yeah, Debbie, why are you shaking your head?
Filled out an application that
Yes,
has
yes.
previously.
Yes.
they might use another address for mailing rather. It's not even a post office box. They might have it just mailed to somebody else. But if you do, I mean, we email. I'm gonna say a move-in packet, the lease. Let disclose, the whole shebang, FEMA, all that stuff. We email them their whole packet. They prefer to have it emailed and then they can keep a record of it. So it's like, we know we have a good email address.
Well, how about this?
Oh, I was about to say that.
How about this? Because I'd like to move on.
But you get.
How about
See that they.
what's in 772, except
No, email it to.
that hand delivery alone is okay. Nailing it to the door alone is okay if the tenant has not provided a mailing address.
So it would be, I'm sorry, say that one more time.
Okay, so it's 772 plus, in other words, 772 says it's got to be receipt of I see you, Elizabeth, give me 1 minute. It's got to be a receipt of notice, and that consists of delivered by hand or posting on the door or email and mailing. But if, and I'm adding, if the tenant has not provided a mailing address, posting on the door is sufficient. Okay?
So I will try to figure out a way to incorporate that.
Okay, I'm sure you can.
Yes.
Elizabeth,
Thanks. What about places where, like my own, where we don't ever use the front door during the winter months and rarely during the summer months? So we may never see a notice that's been placed on our door. Not that, I mean, we own our house, so that's not what I'm talking about, but sometimes the notice may be weather dependent is all I'm pointing out.
I think that would be a rebut to the presumption. I mean, if someone said, I never found it, I never saw it, maybe they put it on the back door, but not the front door or something. But I think there would be mailing too. So you'd have to have somebody who didn't have a mailing address and it was posted on the wrong door.
But didn't you
Actually,
just say that posting on the door was sufficient without mailing?
when the tenant had not had decided not to provide a mailing address. Only under that circumstance. Otherwise, mailing and posting is required. Yes,
Some states actually allow you to use your key and just post it on the inside of the door.
yeah, I don't know that we want to do that.
I'm just saying,
Yeah,
some
I-
states do that.
Okay, I would like to move on to failure to pay rent. Okay. Here, and help me out, Cameron. The issue here is now we're getting into specific notices and the time, not the method, but the time frame. Okay. My understanding is this is when you're saying to the tenant, hey, you haven't paid rent. If you have to pay rent by X date or else I'm going to file an ejectment action. Is that right, Cameron?
In this instance, it would be you haven't paid rent. I assume the landlord may approach it this way and saying that you have X number of days to pay rent. Otherwise, I'll provide you with a termination notice.
Okay, so the current is, here's where you begin to see an effort to seriously shorten the time. The current law is you have to give 14 days notice, right, Cameron?
Yes, sir, based on that termination.
And then what happens? Then after that, the landlord can give you a termination notice, right?
No, currently it's, if you're just saying when is rent due, it's due without demand on the day that you've agreed to
Right.
your agreement.
Okay, so what's the 14 days?
If you fail to pay rent,
Yeah,
so based on the law, it's due on the first, you haven't paid on the second. In theory, I can send you a termination notice.
That's so-
14 days after that.
so the termination notice says, when that happens, 14 days later, what can the landlord do?
Terminate your rental agreement and inform you that you need to vacate the premises.
Okay, that is not the same as starting the ejectment action, right? Okay, so this is an early kind of period. 772 makes it, changes it from 14 days to 7.
Yes, sir.
And 8, what is it called? 688?
688.
688 makes it 3 days. So, and 440, 339 leaves the 14 days. So this is very early in the process, everyone. That is, this is a time when you haven't paid your rent. The landlord gives you notice. At the end of that notice period, what can they do? They can file an ejectment action? Yeah. And then
If you refuse.
if
to-
you refuse to pay, okay. Thoughts?
And two quick things, I should
Yeah.
have started this off, my apologies. It has just been a quick turnaround. I was preparing to have another cheat sheet for the ejectment process. And then, Mr. Chair, you also asked for at least a statutory timeline, not a practical timeline, but at least a timeline of events. I'll try to get you all that tomorrow.
Okay. So here we go. This is the very beginning of the process. It's the time for the landlord to say, hey, you didn't pay rent. You have to pay rent. During that time, people can cure, they can pay rent. And in fact, later on during the ejection process, depending on what we decide, they can also pay rent. But this is the period before anybody's filed a case. And we have range of 3 days, 772 is 7 days. It's kind of like, it's the compromise, and for the current law is 14. So thoughts? Yes,
For like 10 days.
he likes 10. Okay.
I also like 10, but I have another question. So when someone rental agreements, the landlord does not have responsibility of every month telling their tenant to pay rent, correct?
Correct.
So if I'm a landlord, somebody is like, is the current 14 days like the max the landlord can go? Or can, like, on that first day, the landlord say, hey, you haven't paid rent?
So
Like, I just want to make sure I understand that.
So just to make sure you all understand these notice periods, right? This isn't a grace period. This is not a 14-day grace period that individuals have. There is no grace period in statute. So unless the grace period is built into your residential agreement that says rent, agreement could say rent's due on the 1st, it's considered late on the 5th, right? That would be a little grace period that you as an individual would have where the landlord couldn't consider it late until it was after the 5th. The agreement may just say it's due on the 1st, in which case it's late on the 2nd.
Yeah.
What this section is saying is if you, landlord, are going to terminate the agreement with the tenant based on the tenant's failure to pay rent, you have to provide them with a minimum of 14 days notice before that terminates and you tell them they need to leave.
Gotcha. So the next day, I can, as a landlord, I can say, you didn't pay, you're done in 14 days.
On the 1st,
Okay.
it's due, and the 2nd, they don't pay, you could hand deliver them a notice on the 2nd that says 14 days from now.
Okay.
So presumably that would be what, the 16th? This rental agreement terminates and you need to vacate the property.
Okay.
Okay, and so now, so it's the number, what's at issue here is the number of days. And I only will say we've had, I'm going to characterize this. Forgive me for doing this, but I'm just trying to move us along and everybody's free to recharacterize. Some testimony, on one side, we have landlords saying, will you make this process shorter, please? It's too long. And on the other hand, we have evidence that tenants, it takes them time to do things. They may not get it together, they may not understand it, etc. So 772 is 7, current is 14. What's your number? 688 was 3, 440 was kept to 14. Joe says 10. Any other thoughts?
I have a thought. I make sure. I don't know in the law if it tells you how, because I think if you have 10 days, that counts weekends. But if you have 7 days, it doesn't count weekends.
What does the law presume? Is it presume calendar days
My
unless
understanding is it presumes a day for a day. So it's
calendar days unless you provide otherwise? So it's 10 days and what is the first day? What is the first day?
the next day.
The next
The
day.
next day.
That's what we
So-
decided on.
Someone doesn't pay rent on the 1st. On the 2nd, you issue a notice. Then the first day of the 10 days is the 3rd. Okay. Yes.
And my boss real quick, just keep in mind, it doesn't have to be on the 2nd. It could be on the 10th or the 14th.
Whatever the rent's
Whatever
due.
day
Leisure
you're
of-
sending it, it's
of the
14 days from there.
Right.
Oh, okay. So the landlord doesn't get around to realizing, oh my God, they didn't pay rent.
Right.
Okay.
Okay, so I just want to clarify. So current statute is 14 days. We have heard testimony that landlords are experiencing non-payment of rent for months and years at a time. So I don't think remedying a 10-14 day difference is really going to make a difference because that's not actually what we're looking at here because that's currently in statute. Am I correct?
It's currently 14 days.
It's currently 14 days and they can do this now, currently. And so if we change the number of days in which that's allowed, I don't see how this aspect particularly is going to remedy the issue in which landlords are currently experiencing.
Well, my feeling is there's two separate issues here. One is when it happens one time and the landlord wants to get them out, well, then it makes it faster. Another issue is where the landlord just lets it slide and there's repeated failure to pay rent, which is another issue which is addressed in these bills.
And so but back to this particular aspect, whether we make it 10 days or 14 days, the current statute is 14 days.
Right.
Landlords are currently experiencing this. what difference would making me 10 days do if it's already an issue at 14 days?
The problem we're facing here is that there are about a half dozen or a dozen periods. And when you add them all up, it's very long in the eyes of landlords.
Okay,
The only way to shorten them is to shorten each one. There's no other way to shorten the process. Elizabeth? Elizabeth?
Yeah, thanks. I would really love to understand outside of what 772 is going to do. What can Cameron or somebody just walk through, or Debbie or whomever, just walk through exactly what happens as a both landlord and tenant, not statutorily, but in actuality, just so we can have a picture of. So as Sadia was saying, and I was going to bring that up too, I then don't understand how tenants have months of arrears. I also don't understand how, like, where the tenant arrears program falls into this. Would it be possible to just get a walkthrough of that, what that actually looks like?
I can be super high level on certain aspects of it.
Yeah.
And then, like I said, I will get you some more explicit detail. I won't speak to the tenant arrears piece just because I'm not familiar enough with those different programs, but I can try to gather you some information, or, maybe best to just, I think you have had the State Housing Authority and others in, maybe they could give you some better detail on who's eligible and, how long does somebody have to be in arrears before they can access the program, et cetera. It's very globally.
Yeah, just walking through the process with the timeline.
So you are the landlord and someone is renting your unit. You have a residential rental agreement that says they're going to be there for 12 months. It says that rent is due on the 1st. We're going to presume, for argument's sake, that the individual is paying monthly. The statute contemplates that the individual could be paying weekly. I imagine most of them are paying monthly. So the individual is going along and, they pay the first month, they pay the second month, then they don't pay the third. At that point, statutorily, the landlord could terminate the lease because of non-payment of rent. I imagine most landlords are probably trying to keep individuals in the unit for as long as possible, given the process of having to evict, having to then try to find a new tenant, get someone else in, etc. There is no statutory timeline for how long a landlord must try to work with a tenant. Okay. So then if
Yeah, that's important. Everybody. In other words, and it sort of gets at what you were getting at. In other words, what he's about to describe is what happens when the landlord has decided enough. Okay, it could be after 10 periods or a long period of working with the tenant and it not working out. It could be the tenant saying, I'm not going to pay you ever, so whatever. But this is the moment when the landlord says, I'm going to go ahead with this process.
which is fine, but what I'm just trying to understand is where are the teeth? If we're going to say that this is here, I want it to have teeth. And what I'm trying to understand is if it's in current statute that this is a process and it's up to the landlord, and we're saying, okay, this is what they can do when they've had enough. This aspect of it is not changing much aside from number of days.
Yeah, but listen to him now. There's just a lot of steps and each one of them has days.
Okay, continue, thank you.
Is the operative word that it's terminating the lease first? And then once you terminate the lease, then you can take the next step?
That's what he's,
toward it.
right.
Yes.
And what
Yes.
Elizabeth has asked for, which I think is good, is asking Cameron to walk us through the process from the beginning to the end. So we have that overview. Debbie?
So,
No?
I just wanted to say that this termination notice, it gives the tenant a piece of paper that they can take to places to basically verify that they might need help with rent. And they can take it to agencies and they can say, hey, you know, like, can you help me? Can you help me? And we'll even direct them to agencies to go to. And we even have churches in our area. I don't know what other areas are like, but if it's a one-time thing, a church will help with the rent for that month. So it's almost important to get that piece of paper if you are behind in rent.
that may be a condition required to get access to
Yeah.
rent
It
arrears.
is.
Well, it's proof.
Okay.
But you just don't come to
Aware.
a place, say, I need money.
Okay.
What I'm hearing, this is an assumption that I'm thinking, is that, as Elizabeth had mentioned, like, how do tenants get months in arrears if this is already in law and it's just 14 days? Is it because landlords are, saying, we're gonna give you more time? Like, I think that's the question. Am I wrong?
That's one of the,
Okay, well, let's let, we'll just let them go through.
that's one of the reasons. Another is there's a lot of places in what he's about to go through for tenants not, keep not paying. Okay, go on.
Right, so I can't speak to why something would take that long. It's really a question for the individual landlord. Maybe they've received some rent arrears payments from some entity that has kept the person there for a few months. Maybe they're wanting to try to allow the tenant to have enough time to come up with funds. Maybe they're working on some sort of a different arrangement. I'm sure the individual facts could be endless as to why it takes a landlord this long to get to a point. But I'll circle back to something that the chair mentioned. You have the residential agreement. The person is living there, they're paying rent, they're obligating with the terms. At some point, if the landlord wants to terminate that agreement, the statute says you can only terminate for specific reasons, and there is a time frame where you have to provide the tenant notice. And that's where you have all of these different timelines depending on the circumstances, this little cheat sheet in the far left. If you're terminating via the fact that the tenant isn't paying their rent, it's currently 14 days. Versus if you do not have a rental agreement, your rental agreement has expired, the person has lived there for longer than 2 years. You all have decided if you're terminating for no reason other than you are wanting to get rid of the person being there, it's up to 90 days. So the period could be as short as 14 days now for failure to pay rent or for criminal activity, where the landlord is saying, this agreement is terminated, you no longer have authorization to live in this unit, you must leave. And in statute, you're saying that somebody needs to have a specific period of notice to potentially go get money, to help pay for rent if they haven't been able to come up with it, or to try to secure additional lodging to be able to leave. So I think you all can understand that you don't want a tenant to just come in and say, get out, and you no longer have access to all of your belongings. It is someone's home that they're living there. So you're saying statutorily, for depending on the reason that the landlord is terminating the agreement and telling someone you no longer have authority to live in this location, you're saying it could be 14 days notice, could be all the way up to 90 days notice.
Depends. Yeah. Okay, so take us beyond that then.
So now
notice has
we're-
been given.
Notice has been given, termination of the rental agreement, you've been asked to vacate the property. Now, if the individual does not comply with that termination and request to vacate, what do you do? you as the landlord have to bring an ejectment action. The only kind of teeth that I can, right off the top of my head, point to, Representative Lamont, that you have kind of alluded to is currently under subsection, I think it is K in that statutory section, it says that a notice to terminate, and I'm just going to read it to you, notice to terminate shall be insufficient to support a judgment unless the proceeding is commenced not later than 90 days from, not later than 60 days from the date of the notice. So for whatever reason, you've given the person a termination notice. You have 14 days to leave. They don't leave. Now what do? You have 60 days from that date to bring an ejectment action. Why does it take 60 days? Maybe you need to go hire an attorney. You need to gather the documents together, for whatever reason, it could take time. I'll defer to the individuals on, practicing landlords and attorneys as to why, but in statute, it says you got 60 days. If you don't bring the ejectment within 60 days, you're going back to square one. You have to use a different termination notice to sustain the ejectment action. You file the case, okay? You then have to serve the complaint on the individual. It's a civil action. The individual, based on the rules of civil procedure, which are the rules that govern how parties work throughout a case, throughout the litigation of a case. What are the rules that govern how they interact with each other, how they interact with the courts, how motions are filed, et cetera, et cetera. You filed the case. So now this could be day 16 in theory, right? You've given notice, 14 days to leave. They don't leave. You go in the next day and you file an ejectment in court. You serve the individual. They have, under the rules of civil procedure, 21 days to file an answer. So that's kind of the next statutorily or legally required time period. 2 weeks. At that point, they file their answer. Then
Say they don't answer. Let's go that,
Yep.
they either answer or they don't. If they don't, how long to a default judgment?
my understanding is that's going to be up to the court, right?
There's no timeline,
I do
right?
not believe that there is, I will double check while we're sitting here, but I don't believe that there you would, so what would happen for you all, and we're going back to civil procedure a long time ago. You filed your complaint, the individual has a required time period to be allowed to file the answer, they don't file an answer. At that point, you can ask for, motions of summary judgment, or I'm sure the ejectment action probably says you go in and ask for a default judgment to be issued, the writ, the piece of paper from the court saying that you now have legal possession of that property again, to take the sheriff, to serve on somebody, to get the sheriff to remove the individual. How long from when you filed the motion for a default judgment to when the court rules on that motion? I don't believe there's anything in statute that says here's the time frame.
Is there anything in 772? There's 772. Well, I'll tell you what, why don't you just continue walking?
Yes,
through?
because I'm gonna give you these in writing. I'm gonna give
Okay.
all this to you in writing. Let's say the person files an answer and makes their own arguments as to why termination shouldn't be authorized, right? You're terminating somebody because you're claiming that they're conducting criminal activity on the property, and their answer is saying, I'm not. Or that part of their answer is, well, I never got your termination notice.
Or I actually, as a legal aid attorney, had a case where my client said I paid.
Right. So.
Did they pay?
Turns out they did, but I lost the case. I'll tell you something.
So it could be for any reasons they're answering. They're saying that, the reason you're arguing to terminate my lease isn't sufficient, doesn't apply, whatever. They filed their answer. There is currently no statutory time frame between when the answer is filed and when the court has to have the hearing. I think you heard some testimony last week that the courts have a self-imposed expectation of trying to get to things within, I think it was 180 days, the person said. But there was a specific percentage of cases, they're only hearing X percentage of cases within their own self-imposed timeframe. Don't quote me on that. I'd go back and listen to the testimony. I don't remember if it was 180 days, but it was some number around there. So it could be, you've got your 14 days notice, then you've got a minimum of filing. You have to find the person, serve them, however many days that takes. They have 21 days to answer. So we're at a minimum of, what's that, a little over a month in statutory requirements. Then it's up to when the court hears the case. And we
Okay.
need to hear from judiciary on how long that takes.
Okay, so then after the court issues a judgment, let's say, what happens next?
So the court issues the judgment saying that you have the legal right to the premises. They issue you a writ telling you that. And you then have, the sheriff has to go deliver that onto the individual.
There's no time difference, forgive me getting in the weeds, between the judgment and the writ.
I do not know. I would want to double check this. Presumably no, but
It's not like you get a judgment, and then you have to go in for the writ.
You mean when the judge issues a writ of possession?
Okay, they issue, that's what happens at the end of the trial.
Right.
Okay,
But the judge it's up to them, they might give 7 days or 14 days before the landlord would have possession back.
okay,
so the only thing the statute says is the writ is issued. So if the court finds the plaintiff is entitled to possession, the plaintiff shall have judgment for possession and rents due, damages, costs, etc. A writ of possession shall issue on the date judgment is entered.
okay,
The writ directs a sheriff to serve the writ upon the defendant and not earlier than 14 days after the writ is served to put the plaintiff into possession. So the tenant gets another 14 days before the sheriff will.
so they serve the tenant, do they then have immediate right to eject the tenant?
No, that's what it's saying. It's saying the writ directs a sheriff to serve the writ on the defendant
After 14 days?
No,
and not earlier than 14 days after it's served to put the plaintiff into possession. So the judge issues the judgment in your favor, issues the writ. It goes to the sheriff. I don't know how long it takes to go to the sheriff.
There was, I can tell you, it's really not here, but there was last year a bill, apparently it had to be the sheriff, that was the sheriff in the local community,
Yeah.
and they were way behind and they just wouldn't do it. It took, like it was a month to get the sheriff to serve the writ. So now they took that out, so it can be any sheriff, but I still think there are delays in getting the sheriff. But the next step is after the judgment, the sheriff,
Goes to the sheriff. The sheriff has to deliver it upon the person. There's no time frame as to how long that takes. And then I've issued you, similar to the termination notice, right? You've got a notice to terminate.
Okay.
I've issued the writ of possession saying the judge has declared that Cameron Wood has legal right to this possession. You have 14 days to get out. And if you're not out in 14 days, this is how I assume it would happen. I'm not a sheriff. The statute says not earlier than 14 days to put the individual in possession. So the person has 14, the way I read that, plain language, the person would have 14 days to get their things out of the house before the sheriff would come back and presumably change the locks and lock the person out.
Right.
Or physically remove the person from the property. So it's another 14 days after the.
right,
judgment.
Elizabeth?
Thanks. A couple of quick questions. Well, a question and a statement. One is that we have learned from the process with Sheriff Palmer of Windsor County that it's now allowed for sheriffs to contract outside of their own county for procedures like this. So Sheriff Palmer, for example, provides services for the courthouse in Barry, which is way out of Windsor County. So, but my question is, and I mean, does the writ simply say the landlord gets to retrieve possession of the unit, or can the writ also have a timeline written into it? I don't know. I'm just wondering.
I don't know if let me rephrase it and state it back to you and let me know if I'm incorrectly addressing your question. I don't know if a judgment could or would give somebody more than 14 days. But I think presumably that could happen. The statute says that the writ is delivered to the individual by the sheriff, and then the sheriff puts the owner in possession not earlier than 14 days. So it could be longer than 14 days. It just cannot be earlier than that. So it's a minimum of 14.
Yeah,
I presume a judge could build in more time if there was reason to do so.
that's what I was wondering. Like, if a person was very sick, for example, or was going through some kind of turmoil that had a potential terminus to it. I don't know, Debbie, you may have more experience or any experience here, but I just wondered whether is the writ the equivalent of a summary judgment by the judge? Is it
The
it's
writ
the
is-
outcome
it's an-
of the hearing? Is it
Right.
is it is it a simple form, or is it prescribed, or is it open to interpretation by the judge?
I imagine it is a template form that the court probably uses, and it is a summation, I guess, of the case and the judgment that the judge has ordered, issuing somebody legal possession of the property.
I'd be amazed if the judges have terrific discretion. I'd be amazed if they don't have discretion to put in their judgment that the writ, delay in the writ if there's special circumstance.
Thank you. That's exactly what I was wondering.
Yes.
So if the object is to shorten this process, it seems like the length is within the court system.
It's,
And
it's, for example, in the evidence presented to us by the Landlords Association in their chart, they indicate that it's often 4 to 6 weeks after the answer to get a status conference. And then that the hearing is 4 to 8 weeks after that. 772 says it's recognizing that what you just said, a lot of the delay, not all of the delay, a lot of the delay is, this court process. It says from the day of filing, the hearing has to be set within 60 days of that filing.
Okay,
So again, that's one case, right? If you go to the other end of the spectrum where someone is living in a house and they've been there for more than 2 years, you don't have a written agreement anymore because let's say you had 2 12-month agreements, it expires. Now they're 3 months into the 3rd year, but you haven't renewed the written agreement, so there is no agreement. The termination period is 90 days. So now you've extended that. But there are only a few instances where the statute specifies a specific time frame. So if you're going to go in and shorten anything, you have limited circumstances of where you can go in and do that, unless you want to inject an entirely new process into what would probably be the ejectment process. To
So-
say that a court has to do something within X time period.
So now that you've heard this, I'm going to skip ahead and just summarize a little bit. 772 and 688 shorten timeframes. They shorten the pre-trial timeframes and they shorten timeframes in the trial. 440 and 339, pretty much
99.
99, leave the current timeframes. In terms of first set of notices, that is what's right at the top of the page that I just gave you. Those are all notices that refer to this very first notice, this early stage. And those notices, the difference is there are lots of reasons for termination. One is people don't pay rent. That's under the control of the tenant. They may not have enough money, but I mean, it's the tenant's control. Another is they damage the property or conduct illegal activities or otherwise violate the lease. Okay. Then there are a whole series of things that landlords can do to effectively terminate things that really is in the control of the landlord, not the tenant. The landlord decides they want to convert it to a condo. The landlord decides they want to convert it to family use. The landlord decides they want to substantially renovate it so much that nobody can live there while they're doing it. Those are all within the control of the landlord. What you'll see is that generally speaking, under current law and under the proposals, 772, and I believe 688 as well, treats those two groups of things differently. The ones where someone's not paying rent, we just discussed, it's 14, one at 772 is 7, 688 is 3. In terms of the breach of agreement, where the violent or illegal stuff, they're shorter time frames. In terms of the ones that are in the control of the landlord, conversion to condo, government taking, substantial renovation, conversion to family use, the current law is a bit longer, right? It's 30 days. The 772, as I meant it, is substantially longer because it is in the control of the landlord. 772 gives the landlord the requirement that if it's in their control, they got to give 60 days notice to a tenant who's lived there less than 2 years and 90 days notice for a tenant who's been there more. These are before we even get to litigation. So in sum, if you're not paying your rent, it's either 14, 7, or 3, depending on which we go with. If you are engaged in criminal activity, it's 3 or 14. The current is 14. If you terminate, the landlord terminates because they feel like after the rental agreement's over, they want to terminate, or anything else in their control, it's 60 or 90 and 772. What is it? And it's in current law.
Current, it could be 30, 60, or 90.
Yeah. So this is not the litigation part. This is a notice, that first notice, and it differs law currently and the law under 772 and the law under 688 differentiate between situations under the landlord's control and situations under the tenant's control. Yes, Elizabeth.
I am sorry to ask this, but I still don't understand, just help me understand the termination notice. So if a person receives termination notice, that is notice of termination. There is nothing that a person can then do to satisfy the landlord to get to reactivate their rental agreement. Is that right?
No.
As long as it's for something other than non-payment of rent. If it's for non-payment of rent and you pay rent during that period, then the landlord cannot terminate you during that rental period.
It's a cure period for non-payment of rent.
But if it's for anything else, if it's for I am terminating because you've breached the rental agreement or you've done criminal activity. The only defense that the tenant will have is if there's an ejectment action brought, if they're not able to make in some sort of verbal agreement with the landlord.
Right. But, okay, wait. My question is, so if they are able to remedy the rent problem and their rental agreement is reinstated, assuming that it goes back to its, original terms, which has an end date for, whatever. Is there a limit in statute on the number of times that a tenant can do that to a landlord?
Can fail to pay rent and then receive a termination notice and then.
Yeah,
pay
is there a
rent?
number, is there a limit on termination notices due to non-payment of rent?
No, there's not a limit. There is a section that addresses when an individual receives multiple notices. And then there is the section I mentioned earlier where the landlord has a cap 60 days to bring an ejectment action. So
That's not,
Yeah,
I'm
that's
just
not what
saying,
I
like,
mean.
if you send one and then you pay rent and then, 3 months later you fail to pay rent and I send you another one, I can't go back to the first one and say, we're gonna go all the way back and claim.
Right.
No,
this.
nope. I just
That's right.
mean, what if the tenant is a habitual,
right. There are, in answer to your question, under current law, there's no limitation. Under the proposed 772, and I believe 688, I'm pretty sure, has specific provisions on a repetition of that pattern, and that under 772, a repetition of that pattern is grounds for termination.
for termination at the end of the lease or termination at the last notice of termination?
Termination after 21 days, so it would have a longer.
Is that what 772 was? Yeah.
Yeah, 772 includes as within the section that says, so remember subsection A, you have non-payment of rent. Subsection B1 is breach of material terms of the rental agreement. B2 is criminal activity. Under 772, it says breach of a material term includes repeated late payment of rent. So at that point, if you've had multiple late payments, you keep paying, so I can't terminate you under subdivision A, but you keep paying late, I can terminate under subdivision B1, which includes a 21-day time period.
Is that
under
current law or
current.
772 or both?
Current law is 30, 772 reduces it to 21.
Right. So essentially, 772 is a kind of somewhat reduced, and 688 is more reduced about all these termination times. Yes,
I just have a question about lease violation. Let's say the violation is that they need to have heating fuel. And they can
The
remedy that.
tenant needs to.
Yeah, then
Okay.
you get your notice because you're in lease violation because you don't have fuel to heat the apartment. And they could remedy that by having fuel. But so that would remedy that notice.
right.
And there's no
It's a cure. You can cure the
cure that.
So there are only limited circumstances that can happen, as I mentioned, for rent, et cetera, for, potentially the lease violation that you've described. But back to Rep. Burrow's question, under any other circumstance, if the landlord is terminating the lease at the conclusion of the rental term, or if there is no written rental agreement, they're terminating for any reason. The landlord doesn't need a reason, then at that point, the tenant doesn't have a recourse, if you will.
In other words, for each one of the ones that are in the tenant's, in the landlord's control, I want to rehab my building. I want my family to move in. I don't want to release to you anymore. The lease is over. Those are in the landlord's controls, and 772 takes the position that in that case, you got to give a long notice. The tenant is not at fault. The tenant has been paying. It's the landlord's plans for the use have changed.
what people keep referring to as the no cause evictions.
Right.
But at the end of the day.
I've tried to eliminate, I think it's the problem with the terms for cause and just cause and no cause is they're loaded terms. They've loaded up. I think it's better just to deal with each of the causes. So you have in front of you some options. Do you go with the current law or do you go with an accelerated version or vary? For example, Joe was saying, I don't want to go with 7, I like 10 or whatever. I think we just have to, I'd like to know what the sentiment of the committee is.
Mark,
Let it go fast.
Yes,
are the dates that we currently have in 772, are they consistent with the comments provided by Kathleen Burke about Section 8?
we would need a section that council can talk about. We will need, council is prepared. I forwarded all of Catherine's testimony to Cameron and he's prepared to draft an exception which makes it clear that this does not apply to federal lease, where it doesn't apply to federal lease.
Yeah, it
Thank you.
currently doesn't apply, and I will draft up something in the next amendment version that you all review at whatever time that is, that will include something specifying that. As she mentioned, you can't control the timelines under the Section 8 housing, et cetera, so.
Is it, I just want to, I just want to say that if we foreshorten the timeframes so that they're dramatically shorter than what's required by federal law for Section 8 housing, then it might be a real deterrent for potential Section 8 landlords.
I don't think, I have to say, having been through that myself, when you are, Section 8 is a very positive thing for landlords because it's a guarantee of income. It
Yep.
really is worth it. And federal law, we had, for example, in the store that I did, we had a lot of federal money. And there were some really heavy things that federal law brought. For example, you have to pay tenant relocation expenses. And the relocation is not just like 1 month, which is one of the options here. It's the difference between what they were paying you and what they have to pay in the free market when they find a place. We had to set aside $10,000 for that. So people put up with the federal because of the benefits. Do people have an opinion about any of this they wish to express?
About the timeline changes?
Yes. Tom?
I think it'd be easier for me to decide on any individual timeline once I can see the aggregate.
The aggregate, okay.
The difference.
Would people like to do it that way? I think that's very reasonable. Well, the timeline issues, after this, my first section here, the next thing is the litigation. Just to repeat, and then let's go on. To repeat, just so you got it in your head. Current law, there's current law, which is fairly long. There's 772, well, and there's 688, which is much shorter. And there's 772, which is in the middle, but also susceptible to change as well. Okay. Although 772 takes a fairly strong difference between things that are within the control of the tenant, like, well, nominally, payment of rent, destruction of property, etc. on the one hand. 772 says failure to pay rent at 7 days. Criminal activity, 772 is down to 3 days. All the rest, conversion to condo, conversion for family use, substantial renovation, it's 60 or 90 days, depending on how long you. Okay. So maybe what we should do is go to the litigation part. Should we do that?
Yes, but I think you had a member with their hand up.
Was your hand up? I thought you were waving it around. Okay, should we go to the litigation?
Yes, sir. Happy to.
Okay. If you go to page 3, I think it starts from. Let me just see, page
Yeah,
3.
the tenant's rights advocate and right to counsel at the bottom of page 2, but if you're just talking about the time frames, going to page 3.
Well, I'll tell you what, let's go into litigation. I'm just gonna tell you, and we'll come back to it. One issue is 339 and 440 give the tenant, create a tenant's rights tenant's rights advocate. And no, 339 creates a tenant's rights advocate and right to counsel. I presume there's an appropriation. I don't know what it is, but I presume it's there because there would have to be.
I
Or-
believe there was, I don't recall what it was.
Right, the other bills do not. The time to answer the complaint is the next, if that's at the top of page 3. I didn't remember what it is under current law,
It's just the rules of civil procedure, which is 21 days.
21 days.
Can I just have a general question
Yeah.
about this? So this next conversation, is this something that our committee can change, or is this something that would have to go to judiciary?
This will,
and
the whole
change?
bill will have to go to judiciary.
I believe technically it's under the jurisdiction of the judiciary committee, because it's dealing with court process.
Right.
But I don't know if that prohibits you from recommending an amendment. to
I
the
think we
bill.
want, if we can, we should do the whole thing and then it goes there. I think the whole thing's. go
I
there.
just needed to know.
Yeah. Yes,
I
Debbie?
think as far as answering the complaint, I think if they show up, if they haven't answered, but they show up at the hearing, they get like another 10 days.
There is currently, depending on,
Great. We'll take a break at 3, okay? Is that okay?
I have to be at a companion committee at 3:15. just so-
Oh, okay. What do we do, guys?
Well, we've still got 20
Yeah,
minutes.
keep going.
Okay, keep going.
Okay, so the current statutory structure mentions 2 subsequent processes, if you will. So as I mentioned, you've got the termination notice that's been provided, individual files the ejectment action against the individual. The individual has the time period to file an answer, and then at that point, the court process that plays out. Currently in the ejectment subchapter, there are 2 specific sections that deal with 2 subsets of this entire process. First off, the complainant, the landlord, can file a motion to have rent paid into court during the process that the ejectment action is playing out. And then there is a specific time frame about hearing on that motion and when an individual can file an answer after the hearing. I'm not going to deep dive on this unless you all want to. It doesn't deal with the overarching ejectment action itself. It's a specific motion determining whether the individual should continue to pay rent into court. And there are expedited processes for hearing that.
In other words, there's a process in, remember, once you get the notice of termination, you still have a cure period of however many days we decide. But also, there's another chance, which is during the court process, if the judge agrees to it, somebody can pay rent into.
And so to answer the specific question, Representative, the way that works is there's a hearing on that motion and the tenant has 14 days to answer after that hearing. So there already is a separate time frame.
But someone would have to move, the tenant would have to move to pay rent into court.
The landlord would.
So, oh, the landlord can pay.
I assume the tenant may be able to, but presumably it's the landlord.
Debbie, when does this happen? Why would a landlord move to pay, if the tenant has to pay rent into court?
Based on. Yeah, but probably-
No, you can explain it.
I was just saying, I mean, based on how I read the statutory section, I mean, if you're, let's say you're terminating somebody for a reason other than non-payment and you want to ensure maybe they're contesting it. You're saying that they're conducting criminal activity and they're saying, no, I'm not, they're trying to stay in the location, I would ask.
And the landlord says, yeah. I mean, it's a reality. Part of the problem that landlords have is that very often, as soon as they file a motion, as soon as they file a case for ejectment, nobody pays rent. It just stops. Okay,
Okay, so that's one, and then there is an expedited hearing process for an unlawful occupant, which is not someone who has stayed there. My reading of this is not someone who has stayed there after a termination period, somebody who is outside of the rental agreement process itself is illegally in the place.
Mhm.
They weren't the tenant to begin with, for example. Tenant has left.
right.
Somebody's staying there with no authorization to have ever been there in the first place.
Okay,
What page are you at? Is that
Page 8 of 12.
Thank you.
That's on this one, yes, ma'am. The blue one though, not the gray one.
so it's 21 days under current law.
Yes.
688 and 756 make it 5 business days to an answer.
Correct.
772 said 7.
Yes, sir.
I put, there's an issue here. We did hear testimony from, I can't remember who it was. CVOEO, I'm not sure who it was, testified examples of people of why they thought that very short times were a problem because the people didn't understand what their obligations were, didn't have the notice. Then Angela Zakowski, representing the landlords, testified that they have an answer attached to the complaint and it's simple to fill out, she said, and she's seen fewer defaults. So that's the state of the evidence before us. One of the issues we have to decide is, do we want to go with current law, 21 days? Do we want to go with 5, 7, 10? We got to decide.
Wait, I'm confused because I'm reading 10-day notice. You're saying not specific to the somebody else moved in.
Right, that's different.
Okay,
Look at page 5 of that,
yeah,
section by section.
self back. Okay.
Like 10 days.
I've got a question.
Yes,
Since our current law allows for an unlimited amount of deposit, is there a role of that deposit in any of this process?
You're referring to a security deposit?
Security deposit. If say a landlord requires 6 months of security deposit, is there a role for that in this process? Or if a landlord requires first, last, and deposit, where does the last month's rent fit into all of that?
as a practical matter, the landlord has to apply the security deposit for damages to the property. They have to apply the last month's rent to the last month. As a practical matter, these ejectment actions take so long that the tenant never gets back the last month's rent because it's consumed, but in non-rental payments or destruction of property cases, in those cases, generally speaking, by the time the whole thing is over, the landlord hasn't received rent for 4 or 5 months or longer.
But is there a legal requirement, sort of prioritization of how
Yeah, but you can
how those
access.
monies must be used, or whether they're required to be held in escrow, or whether they are required to like be designated first month's rent, last month's rent deposit, and then used as such? Is there any kind of statute surrounding that?
There is a statutory section that governs security deposits.
Or prepaid rent.
And it says that the landlord may retain all or a portion for only these four things: non-payment, damage, non-payment of utilities, or expenses required to remove the rental unit articles abandoned by the tenant. And then it provides that the landlord has to provide the security deposit back within a specific time period, and the landlord has to provide basically an itemization of what they have deducted the security deposit for within that time frame. And if they do not comply with that, which is 14 days, then all of the security deposit has to go back to the tenant.
So it doesn't say anything about last month's rent.
It does, it includes any other
It says you can
deposits.
use it for non-payment of rent.
But
Or if you're
wait,
talking about what,
scroll up.
That's
it
still the
says,
security
a
deposit,
security
though.
deposit is any
Right.
advance deposit or prepaid rent, however named.
so even if you name it last month's rent,
It's pre.
I would argue that it meets the definition by the fact that this section says prepaid rent.
Okay, thank you. And it doesn't have to be held, it's not required to be held in escrow.
No, ma'am.
Huh.
There is a bill that was proposed that would require it to be in a savings account.
Debbie,
My thought is if any landlord is required 6 months, they're not gonna have any tenants.
well, that's about the secure, I'm trying to keep us on target here. I think we have to go in some order. This is not, this part of the discussion is not about security deposit. I'm not saying Representative Burrows was wrong to ask because she's saying they're connected. But the question is, time for answer. Any opinions? Joe hasn't expressed an opinion of 10 days.
This is time for answer on which aspect? Is it on, are we past the unlawful occupant expedited? Where are we now?
This is on if the landlord has brought the ejectment action against someone.
Mhm.
Currently, it's 21 days for that individual to file an answer to that action.
So for all purposes, ejectment,
Any ejectment that you bring whatsoever, whether it's failure to
Thank you.
pay rent, whether it's criminal activity, whether it's.
whatever it may be.
Yes, ma'am.
Okay, thank you. So we're back to the beginning section.
Beginning
Or,
of the
or
ejectment
of the
piece.
ejectment piece. Okay, thank you.
Tom?
So what is the chance if this goes only to a bench trial? It's a trial date can be set 60 days or less from the filing, because if we cut that number to 60, the other numbers are not quite as critical. We don't cut it to 60, they don't make that much of a difference.
They make some, but they don't, yeah.
So that 60 days or less from filing seems to be the number that makes the most difference.
It is the biggest difference, yes.
Okay, is that, so if 772 makes these bench trials, not jury trials, does that help close that, bring that number down?
It does because according to the testimony, it's the only testimony we received on the subject, says that 4 to 6 months for a non-jury trial, 6 to 12 months for a jury trial. Yes,
Is that 21 days, calendar days? I know you mentioned it, I forgot. I said.
unless otherwise, it's 21 days. Unless you hear otherwise, it's just calendar days.
Okay, then I'd say 14 days. 2 straight weeks.
Let's take the rule that I always like to take when we're dealing with a complicated subject. nothing is decided finally till everything is decided. So, for example, if she says 14, Joe says 10, there's no vote on this. We're just telling him what to put in the next draft. There's going to be another shot at it. What we're trying to do is learning our way to get our hands around the whole thing. So we have two positions here, 14, 10. Anybody else?
I'm fine with 14 or 10 business days, which equivalents to the same thing, so.
Debbie likes 5, yes. Any other expression here? Okay, well, let's go for the moment with the most permissive, which is 14 days. We did have a fancy approach over here, which was 10 business days, but are you okay with that? Okay,
Just saying.
okay, 14 days. Okay, the next item is an important item, guys. Really important. Jury trial. This is a big deal. All of this is going to have to go to judiciary, but I think we should work this out. Am I right in what I'm saying that every other bill allows jury trial?
Correct. 688 simply reduces some of the current time periods, and 756 creates a limited expedited process for a limited subset of determinations. 772 is the only one that creates a process and removes the jury trials.
Now, I have to tell you, and I'm assuming for you to have put it in my bill, Cameron, that you believe it's constitutional.
I personally don't see an issue with it. It's not a criminal matter. It's a civil matter. I will confirm with our judiciary team that they do not have any issue. They have not expressed one to me to date on this provision.
Generally speaking, constitutionally, to my knowledge, I don't think there is a right to a trial by jury in civil proceedings. There are a lot of statutory variations on whether you have one or not, but so this, just to make it clear, means you're going to try, if you go with this, you're going to try it before a judge. Can't ask for a trial before a jury. You can ask, but you won't get it. So the question, and this is a jury trial is, according to the only testimony we have, kind of doubles the time. Joe.
The failure to pay rent and breach seemed perfectly fine with that. My question was when, I don't know if saying like the material facts would be criminal activity that you're being evicted. In that case, would it be okay to do away with that?
That's a really,
Yeah.
we have I think we have a nominal lawyer with us here. Raised a really interesting question. I know I just insulted you in the worst term.
I don't know if those are the correct terms supposed to use.
I'm just gonna highlight something that happened last week. We were talking about this, and if you recall, there was language towards the earlier part of his bill 772, which talks about a nominal fee. And he said on the record, I think, that he like hated that term or something like that.
Yeah.
He just used it.
Oh.
So, but he is raising an issue. Let's put it this way. He's raised an issue. Would you check with the judiciary team? Will you also double check? I mean, it's for illegal activity. And the landlord, which is usually, I mean, I can see ways around that. It's for violation of the lease terms. Specifically the lease terms concerning an illegal activity, which is different than someone, for example, a lot of leases don't smoke because people worry about fire. Okay, well, what happens if someone smokes in the building? That's not the same thing as, it's just a different, it may have to do with safety, but it's not the same thing. So that's an open question. How do people feel, that question, assuming it's legal, how do people feel about the jury trial issue?
I'm perfectly fine with getting rid of it as long as it's appropriate to.
I am too.
I don't want to like dance around the edge of something. If it's clean cut, we're good, then I'm fine with it, but I'm not.
You want to know, yeah. Others, you're okay with it, other opinions?
I think a jury trial will take forever.
So
You can't get jurors anyway, and it just would go on and on.
So in the instance of an affidavit and evidence, criminal activity being followed up with a show cause requirement, which I think if there is illegal activity is not likely to happen at all. But if somebody does say, I can show cause that this is not happening, can they appeal that? This would be their.
No, if someone, the way 772 works, and this is important because we've heard a lot of testimony that both for-profit and nonprofit landlords are suffering a lot from this problem. So the landlord has to put under penalty of perjury together an affidavit.
Right.
If within a week, there's a show cause hearing. At the show cause hearing, if the tenant gets up and says, I do not do this, the landlord saw this, but it meant something else entirely, and I am not a drug addict and I don't sell drugs, then it goes to a hearing.
Okay, so then, all
And
right,
the hearing has to be within 30 days under 772.
that's a separate question. Okay.
Yes,
Okay, so then it goes to, I just want to play this
Yeah.
part out because I have a lot of issues with the presumption of criminal activity by civilians. So if they go to court and they take it to trial and it's found that it is in fact not criminal activity, this person is
then
not
the
engaged.
landlord loses.
The landlord loses, but then what happens to that tenant
The
who
tenant
was falsely
pays.
accused? But do you understand what I'm saying? Like, that's a whole extra layer, which is the only reason why I didn't want to, like, I said, that is something that I don't think we should be engaging with. But I feel like that is outside of the purview because the level of damage that will cause is significant. I mean, could you imagine?
So what is the new thing that we're doing that we don't already do? What are you suggesting is more damaging in the new proposals that you might not want to do?
I'm just saying it's fine. It's fine with the current statute with the time frame with the 14 days for alleged criminal activity that is proven, that is fine. I'm fine with that. I'm just and with the under perjury, I appreciate that. I'm just saying whatever happens after that within the litigation and the court systems, I don't think we should be writing policy on that, is what I'm saying. Does that make sense?
Who should then?
Judiciary.
They will.
Yeah.
We're just giving recommendations. And we could give recommendations to be more strict or less strict.
The problem we're facing is that kind of everything is connected to everything else. Right now, there is a provision in existing law that's called no cause. And under no cause, a landlord doesn't even have to say why. They just deal with the tenant by just taking them out. And that's that. They say you're violating the terms of the lease, you're out. This is just the same, only it's not called no cause. It's called for cause, and the cause is illegal activity under the lease.
Violating terms of the lease.
Yeah.
Okay.
I got a question.
Well, first, did you have a?
Yeah, I was curious, what's up? Is your concern that it's pointing at making a judgment of what is,
Yes.
but why is that different than what exactly is happening right now? Because we're only talking about, well, maybe I'm not understanding what your issue was.
No, just move on. Don't digress, just,
Okay.
Debbie and then Elizabeth.
I see a huge difference between the show cause and the no cause. We have to keep it as a no cause.
Well, it's a no cause in this. On 772 just makes it a cause.
Right.
If you violate the lease, then that's one of it gets rid of the no cause versus cause. It just, but effectively, 772 says if you violate the terms of the lease, then you can be ejected. And
I
it
would
creates,
keep no cause.
Yeah, you are. It's just that it's making it a little bit of a longer process when you don't, when it's you as a landlord making the decision. It's a different process than when the renter is breaching the contract.
772 doesn't make any changes to the no cause piece,
Yeah.
other than making them consistent. Whether you have a written agreement or not, it makes the duration consistent.
Well, we were saying we
Just
have to
thought
do
that
an affidavit that we believe there's criminal activity. Opening ourselves up to a lawsuit if we're accusing somebody and they're not doing criminal activity. That, to me, that's showing the cause.
And that has to show that it's not happening.
Well, that's
yeah.
not hard.
well, that's what they're saying. They're saying, so this puts the power in the landlord's hands so that they're providing this affidavit stating that this is occurring. So then it's up to the tenant to prove that this is not happening. You understand what I'm, well,
I understand
Yeah, so
completely, but
that's-
I think it's very easy for the tenant to prove that that's not happening.
okay, the reason, just to be perfectly, I'm sorry, go ahead, Elizabeth.
My question is, if a tenant were to be accused of illegal activity and they went to court and it was found that they didn't have any illegal activity, would that case remain on their tenant file?
Yes, as no ejectment.
I get what you're asking. It's, if you're a landlord and you're able to see that, you're gonna say, oh, something happened. Whereas if you're a tenant and you've never even started or anything like that, and so you have two tenants, you see no
Right.
ejectment versus nothing.
There is a way to deal with it. There is, I can think of a way to deal with that, which is there's a provision of a whole long provision of 772 that creates that the entire proceeding is confidential until judgment. It could say until judgment for the landlord.
Yeah, it's provisions that we haven't reviewed or discussed yet, but in 399 and 772, there are provisions about either expungement or confidentiality of records. So.
We could provide that it stays confidential unless there's judgment, unless and until there's judgment for the landlord. Then at that, in response to concerns Saudia and Elizabeth have raised. So if someone,
I'm good, I don't have any.
yeah,
concerns. I'm good.
okay.
Well, real life experience is that you can have I'm gonna call it a drug bust in the apartment. And so you've already notified the police that you believe that there's criminal activity going on because that's required by us. And they're like, yeah, and they tell you just be careful. And then they have their drug bust and then by noon, they all go to court, pull 9 people out, they all go to court, they get their court date and they're back in the apartment by noon and they're still dealing drugs. And you cannot go to court you have to have a police report and the police will not give you a report because it's an ongoing investigation. You can't use newspaper articles, you're very limited. The only thing you can have is a police report. You can't even have somebody that was, police officer that was involved in that and write a note to the court. You can't even have that. You have to have the police report. So when you go to this level, it's like
Okay,
proof.
what we're talking about now is whether we have is fundamental questions about what we have with this accelerated process. I'd like to ask, are people comfortable with the next draft continuing to have that there's no jury trial?
With my cat.
Okay, so we've decided that.
With the caveat.
The time for setting a trial. Current law has no requirement, as counsel has said. 772 requires a trial date to be set for 60 days or less from filing. I personally expect that there may be testimony across the hall that says that that's difficult, and we'll have to deal with that at the time. But my own personal feeling is if we don't do that, we're not going to address this problem. So I think we can stick with the 60 days. I think the issue next is whether whether we should have an expedited hearing for alleged criminal behavior. In other words, one option is just to simply allow ejectment to proceed on the basis of a violation of the terms of the lease. 772 and 688 and current law. Does current law have an I'm now on expedited hearing for criminal activity. Doesn't current law have,
Not criminal activity.
there isn't a mischief section? No, okay. So both 772 and 688 deal with this problem of feeling of growth. And the problem that I'm going to just lay out the problem so you see it. Landlords, like, for example, the nonprofit landlords testified, Michael Monte and others testified that it's a big problem and that they want something that will help them in the situation Debbie described. That is the situation where it's difficult to prove, drug dealing is difficult to prove because the normal people who could testify are other tenants. Okay? So, in an attempt to address this issue, 772 creates this accelerated process, show cause process, where the landlord has to swear under penalty of perjury, whatever the facts are, and the tenant has to rebut them. The tenant successfully rebuts them, it goes to trial within 30 days. If the tenant does not rebut them, the landlord gets possession. That's what's in 772, and a form of it is in 688. Now, what legal aid and CVOEO to some extent testified that they don't want to see this process because they just don't think that an allegation of criminal activity should be decided by anyone but the police. The problem is that takes forever and in fact often never occurs. And the landlords assert, well, we have a right to put in our lease that you can't engage in illegal activity. And so we ought to be able to do that. And that's kind of the issue that's at play here.
So the language is around, I'm going back to terminate. I know you're talking about like criminal procedure, but so this is still falls into violation of the lease because it says based on criminal activity, illegal drug activity, or acts of violence, any of which threaten the health or safety of other residents.
Right, it has to
The
do, it has to
landlord
do that.
may terminate, provide, okay, great. So I think this is a health and safety issue. If it's causing challenges to the health and safety of others, that is a valid reason. And this is, I mean, this is the point. This is what we want. You want people to have valid reasons for doing things. And I'm just gonna say, to not use the word just cause, it's like saying mobile homes, manufactured homes. We're changing language. Okay, the word is the word is. It's not a loaded term. It is what it is. And if we're going to change terminology, then we should do that. If we're changing what it means, or we're not changing what it means, but we're going to say the same thing because it appeases other people, it is what it is. But I just say, if it says which threaten the health and safety of other residents, and then we also have damage to the dwelling in yours, 72 to the unit or premises or other activity, I'm saying, like, these are valid things. You understand what I'm
I
saying?
should tell you, you're right on something. When we were drafting this, I wanted to avoid ejectment where someone's just sitting in their unit shooting up themselves alone, not causing any damage to anybody else. You know what, the language you pointed out, they're violating the law, but they're doing it in a way that does not interfere with anybody else's health or safety. I didn't want that to be grounds for this kind of ejectment. In other words, I'm agreeing with you. I'm
I
saying.
want to go in there, you
Yeah.
took it a whole nother level.
I'm just saying, yeah, you're right. What the key, yeah, you're right. The key is something that is, what's the words you read them? Compromising the health or
Yeah.
safety of.
Threaten,
Right.
to threaten the health and safety of the resident or damage to the dwelling unit, premises, or other activity. And I think, like, this is what we should be focusing on, is this is what we're hearing, is that there's needles being found, there's whatever, people coming who don't belong there. And that's another whole thing I have a question about. We discussed it last week when you were talking about when I was trying to get to the shared occupancy. And then today you started to talk about who is considered in the what was that language? Hold on, if I can real quick. Unlawful occupancy, thank you. So, like, I think there just needs to be this, I think for me, what I would love our committee to do is to clean up that language, unlawful occupancy, the things that threaten and damage, the things that we heard that are causing the problems. Let's fix those things. Let's put language that actually addresses those things. The timelines, let's clean them up so that they are reasonable and realistic. I mean, like, giving someone 3 days to pack up their entire life and move out is not realistic. That's just going to cause problems for everybody. No offense, but it's just not humanly possible. But I'm just saying, like, let's really, really do the things, and the language matters is what I'm just saying. That's my 2 cents, and I'll stop.
You know what, you're
Sorry.
about to go. One thing that occurs to me that you might try to think about writing up is, what if we didn't talk about criminal activity? What if we didn't list those things out? What if we just said that a violation of a material term of the lease that endangered the life or safety of other tenants? And then have the accelerated process for that focused on that, as opposed to violations of the lease with, like smoking. That, yeah, you could eject people if they repeatedly smoke, but not through this accelerated process. Elizabeth, do you have anything that you
I
want?
totally support that, Mark and Sadia. I was just going to make a comment about the criminal activity. Really, I feel like it wades into due process, and I don't think we should be touching that. I
Yeah.
agree with preserving and protecting health and safety of all tenants, 100%, and property.
Okay, we're we don't have to stop, but we lose our counsel. We can keep discussing. And actually, I gotta tell you, this is really great. This is the way we all learn as we go. And, it's not like we all know what we think at the start. We learn as we go. Yes. Thank you, Cameron.
Yes.
We'll see you again for this. Yes.
Thank you, sorry.
I think the criminal activity, once it is established, if somebody is shot doing a drug deal, that is an illegal activity that no longer needs to be proven. Okay. If arrests are made and it does eventually come to trial and it turns out, yes, the police, I mean, it's lengthy, but at that point, I don't care, if somebody's shooting up on their couch and dropping a cigarette when they're out of it and burning the place flat, that's a safety issue. I mean,
Yeah.
and that's happened. Okay, and that's not. It's not something to mess with. We've got other tenants whose safety is equally important.
Well, I think that,
I don't
I
have to
think,
be doing drugs for that to happen.
right,
There's other things that
exactly.
happen,
That,
but-
this is all to me, given what Elizabeth said, what you said, what you're saying, sounds to me like 772 should be somewhat redrafted. Remember, 772 has an accelerated process buried in it, right? But instead of calling it accelerated process for criminal activity, we just call it accelerated process for material lease, violation of material lease time that are endangering the health and safety of,
Leaving it broad.
Joe.
Hibachi in the hallways would also fall into this. Okay.
Yeah, but I'm not taking that up. Oh, it's not criminal activity.
Right, see?
Okay,
I
alright.
think we're like shifting criminal activity into B1 and the same problems there. We're just putting the same problem in a different section. Where it's criminal
Yeah.
activity that you now have.
Right, and I agree. That's we're talking about.
Not changing.
We're
the problem,
talking-
We're changing
no.
what section it builds in.
Exactly, and what I'm hearing, and I just want to reflect it back, and then Elizabeth, you're next. What I'm hearing is it's okay to have an accelerated process. It's not okay to call it for criminal activity or make it depend on that. It's what's the criteria that matters is endangering the health and safety of the other tenants.
Right, well, the point I was trying to make is that you're shifting from being accusatory to this affects me. So if you have someone, if the tenants are saying, my health is being compromised, like we heard about the tenant who couldn't sleep, right? And lost their job or whatever the case may be. My health is being compromised, my work is being compromised. That is their attestation that their life is being compromised. So if they have to provide an affidavit, like I'm actually trying to help the landlord. Like if you're trying to provide an affidavit, you're providing an affidavit on how it's impacting you. You're not accusing someone else of something. You're saying these things are happening and this is how it is impacting other people. So you can't mess that up, I feel like. Whereas if you're accusing someone else and you have a burden of proof, or you're worried about, are they actually doing that? Let's stick with facts. This is what's happening. This is what is occurring, and this is what's impacting my life. No, is it illegal or is it criminal activity or whatever the case may be? It's threatening the health, safety, and well-being of whomever. Does that make sense?
It does, except proving it still is an issue. So if you find needles all up and down the hallway, you still have to establish, and everybody in that building might know where they're coming from, but you still have to.
That's why the affidavit is there.
Find smoking hibachi and nobody's in the hall. We still gotta, it is almost as complicated to establish it's this tenant.
Which is why you need the affidavit. Elizabeth,
I have a few constituents who have complained to me on numerous occasions that they have children in their apartments, and there is a tenant in the building who smokes pot in the hallway. And it's not illegal, but it really has an impact on the children in the building. It's not the same as sitting in the hallway and drinking your 15th beer, although that's also has an impact on the children. But it does have a health impact. It does have a developmental impact. And if we were able to fix the wording of this, those tenants would be able to have a way to talk to their landlord about the behavior of that other tenant. Just
Right.
as I mean,
Well,
so
that does come under health.
it does.
Very often, by the way, one thing that isn't changed by 772 or 688, just to be really clear, the simplest way for a landlord to address a tenant as activity is obnoxious, but obnoxious, is to just let the lease run out. That's what they do. The problem is if it's during a lease, the lease isn't running out and they're just, creating this problem. And so I would say one way you deal with a pot smoker is that landlord runs the lease out. Another is that it's violating the terms of the agreement.
Right, but then you have to prove all.
Yeah, but you prove it, but at least then people
Yeah,
aren't going to be
cameras in
afraid
the
to
hallway.
testify. Yes, Joe.
Question, I feel like we're just keep circling what the
Yeah.
problem is, which is,
The drain.
no, oh yeah, great. Just like, how do you prove that, like, they're not the police, now how do they prove somebody's actually guilty, right? How do you get to that point? My question would be, is an affidavit from a landlord, is that sealed? Is that open for?
The whole thing is sealed until
Can tenants sign on to that affidavit?
they could, absolutely.
And it can be kept from everybody?
Yes, no, the landlord, I'm sorry. A landlord can go to the other tenants and say, will you sign this?
Yes.
Fear, a lot of times there's too much fear and they won't, but there's nothing that stops other tenants. If you can get, if I
It
was,
stops other tenants.
yeah,
The fact that it's gonna be available to see.
yeah,
After the fact, if the
right.
judgment is rendered.
I think we need Cameron here. I think
The landlord with 6 tenants signed on to their affidavit is.
if we
the
could
hell
seal
of a
the
way.
affidavit,
And it's sealed.
yeah.
And when I come to you as the landlord and say, hey, I'm trying to get the guy out
Right.
or the lady out. Will you
Okay,
sign
I'm
on to
gonna
this?
ask-
It's sealed forever.
Yeah,
by the
can
way.
we seal the affidavit? Okay.
Better.
If it's, I'll tell you what, if people want to stop, or should we go on a little? I could pull it to one issue, which we can talk about that we don't necessarily need counsel here for. Or do you want to stop now? The one I would keep going on is disposal of property of the tenant after the eviction. It's just, we don't need our lawyer here necessarily for that. Here's the deal, and I'd like anyone to comment. I'm going to speak from my own experience. My own experience as a nonprofit owner of the store and 3 units above the store is that it was just really difficult. It's strange, but it was really difficult to get the tenant to come and take their property. They just wouldn't. We kept giving them more time and they just wouldn't do it they kept saying, oh, my mother-in-law will come with the car and take it, and then they just wouldn't. And so we were told we had to give notice, we gave notice and all this stuff, and she got the notice. It's just, I don't know why. You would think there was a lot of the stuff in this, a lot of the stuff in there was junk, but not, some of it was small, some of it was like a TV, things like that. So, and she was living somewhere else. So I don't know why. So anyway, the theory here, what is the tension? Because remember, there's always a tension, right? The tension is From the tenant's side, you don't want to make people clear their stuff out so fast that they don't have any place to move it to. It's not like they necessarily in a situation where they can buy a storage unit, you know. On the other hand, the argument, I'm just going to try to give both sides. So the tenant side is you got to give people a chance there. The landlord's position is, God, they've had months and months and months notice because you gave them notice and then you went through the trial and the whole thing. And how much notice do you need to give? And then in the end, you're going to have to get rid of it yourself anyway. So I'm now tried to play landlord and play tenant. So thoughts? Debbie?
I have a thought, because I know a unit that came off the market because the landlord was exhausted from trying to get the tenant that moved out, whatever way it was, to come get their stuff. And it was the same scenario that you were talking. They never came. And then she has to deal with it, try to find someone to remove it. And she's like, I'm tired of that. I'm not gonna rent anymore.
Well, thoughts?
So,
By the way, the options that are in front of you, which we don't have to go with any one of these, but I mean, current law says 15 days after writ of possession is served. They got 15 days.
So,
Then 688 says immediate, remember, they've had
all that time.
all that time. 688 is immediately after the writ of possession is served. 772 is immediate, essentially immediate too. Yeah, Joe.
My point would be that I think it's kind of that, what that is for me anyway, is going to be tied to the getting the writ and how the math on that works out.
You mean how quick it is to?
Yeah, I'm just thinking, say, 756. Not sooner than 5 days after the writ is served.
Oh, you mean how quickly?
So you've
they can
already lost
eject
the
people.
case.
Yeah, you've lost the case
5 days later.
and you've
is
been
this-
ejected.
Yeah.
You're out of the.
But now you got 5 days before you actually can get that writ.
Well,
Or get
and
that from a sheriff saying you gotta go, right? And is my reading that right?
yeah, that's
Up to 5
756.
days. Up to-
Up to 5 days.
Not sooner than.
Yeah,
So.
and
after you-
772 is 7 days and
Lost the
current law
case.
is 14 days.
I'm thinking that 5 days is 5 days that you know you lost. You gotta go. And then whether it's immediately after that, if it's immediate, then that's 5 days in that case. If it's within 48 hours, now we're talking 7 days after you've lost the case. So I think the map on what we decide.
I see.
The
So
judgment,
judgment for possession and disposal of property should be,
well, it's kind of the math, and what we do on it's gonna
Yeah.
affect the other.
okay. Well, judgment for possession, current law is 14 days. Well, yeah.
So if you've got 14 days and then 15 days for your property, that's 29 days. You could have gathered your stuff up, right? Like if I'm reading it right.
What I don't know, under 772. But I'm sorry, I don't have the council here. Did anyone remember, because he went over this, does anyone remember when you get the writ of possession, okay? And then the sheriff serves the writ not earlier, current law, than 14 days after it's issued, right? So 2 weeks. But does that mean they can eject them then? Or is there an additional time before they can throw them out?
By sheriff,
Yeah,
it would be
when the sheriff serves the writ of ejectment, is that another word for, okay, here we are, you got to get out?
they have to wait those 14 days. So
Right.
maybe on the 15th day, you
Yeah.
could remove them.
Okay, so it's, okay, so I just want to understand that.
If
So,
they're still there.
okay, so right now, after the judgment, the sheriff has to wait 2 weeks and then they can remove them. Under 688, it's 24 hours. 756, it's 5. 772, written by this softy over here was 7. And then the question, so then then when can you dispose of the property?
So back to notices. Once the writ is written and it's served, is there a notice? I just want to make sure that and I'm just playing devil's advocate here,
no,
is
go
that
ahead.
some people, if you, whatever they're not gonna register in their
Yeah.
brain that, oh, I went to court. So, I only, I'm just saying, is there gonna be a notice when the writ is issued, right? Or the judgment, is with the judgment, that they're saying, okay, the sheriff is going to come in 14 days.
If you're not out.
Right. And so I'm just saying, should there be a notice?
You know what? I
You
don't
understand?
know the answer. I don't know. She's asking the question. I'm gonna put it in legal terms.
Okay,
When the judge issues a judgment, okay, and the writ, it's just all one
right,
thing.
right.
Is that piece of paper served right then on the defendant? I don't know the answer.
Like, what's the difference?
Is that constructive notice?
Do you understand what I'm saying? Like, the writ being,
Oh, judgment will be done on the spot, not necessarily. Okay.
so that's what I'm saying. So how do we?
Whenever.
So if they issue it 14 days, and we saying, okay, you have to get your possessions out immediately after. I'm fine with that as long as there's notice, but I'm just saying, if we're not giving notice, like if there's not a clear chain of notification. And I know you're like,
Yeah.
oh, we've been going through this eviction process, you should understand. People, not everybody's brain works that way.
Well, we're gonna make the judgment.
Right, and nobody knows anything, and so I'm just saying, I think if it either there needs to be that timeline from after the sheriff serves. I'm not saying it has to be 14 days, but I'm just saying there needs to be a time frame after that, or there needs to be a clear notice upon when the judgment is issued, that okay, the sheriff is coming within these amount of days.
Sheriff will serve the writ and. he will
Especially if
explain
it's a default
exactly
judgment.
What's gonna happen.
What, Debbie?
The sheriff will serve the writ of possession and will tell the tenant exactly what's gonna be happening when he's coming back. And that he will be removed. I don't care, you can put how many days you want in there. That's exactly what's
That's the
gonna happen.
process.
Well, but we're discussing the disposal of property, that's what I'm saying.
Oh,
So-
I thought you were talking about the writ.
No, but.
Well, I'm saying the number, if we're talking about a timeline between disposal of property, right? We need to clarify the timeline in which the sheriff gives the writ or whatever. I'm just saying it can't be immediately after the sheriff issues, as is stated here, because they wouldn't know. You understand? The tenant
Okay,
wouldn't
I
under-
think
does that make sense?
I've got just a second here.
Isn't it the same for the person and the property? When you're served, that you have to leave with your property?
But I think the question she's asking, and I don't know the answer to, Debbie, to you, is this. The trial's happened. Or it's a default, one way or the other, okay? Whatever it is, it's over. The sign that it's over, it's over, the court part is over. The sign that it's over, well, hear me out. So the trial's happened and everything, the judge has decided, and the judge issues a writ of possession. Okay? A judgment writ of possession. At that moment in time, let's say it's the 15th of the month. Does that writ of possession served on the defendant? Does the defendant know there's a writ of possession out there? Or do they not know anything until the sheriff arrives 15 days later with the writ of possession? Is there notice of the judgment that you lost? Normally, in my experience in civil procedure, when there's a judgment, it has to be served on everybody. But I just don't know. So I think I don't know the answer to the question. You're saying hey, I'm willing to go with the shortened time for the getting their stuff out, as long as they've had notice that they lost the case and that they had 14 days, or whatever it is, or 7 or whatever. But I don't know. I'm trying to find I think we're gonna need counsel.
Well, I'm looking at a sample one. Mr. Sheriff, product said, take the possession of the premises, remove the said defendant and their property therefrom no earlier than 14 days after service of this writ. It looks to me like from the time they are given written notice of the judgment, 14 days later, they're
That's
That's-
current.
okay, that's current. So.
And so that's the problem. That's what we're, so that's what, so this is the herein lies the problem, right? Because the current is within not more than 14 days, not before.
That gives them the 14.
Right, but they don't know until they're served, and then they have 14 days after that is the current statute. So what I'm saying is, if we're looking at shortening that length of time, then we need to up the amount of notice. They have to have notice, because if it's 14 days after they get notice, like, you can't shrink the amount of time from after they get notice, is what I'm saying. That's what I'm saying. Oh, yeah, it came out. Whew, that was a whole circle. So the amount of time from when they are informed that they lost and they have to evacuate, right? That amount of time is what I'm saying matters. I guess, so thank you. That's what I'm saying. The amount of time from when they get the notice to when they have to remove their property, that is the important amount of time that I'm saying cannot be shortened. I'm saying the part that if you want to, how long it takes for them to give the notice, if you want to shorten that, that's fine. But from the point they are notified, they need time. It can't be immediately after they are notified, is what I'm saying.
Yeah.
I'm
Did
sorry.
I make a complete thought? Did that make sense?
I think we have to wait, because I don't know the statute right now. is-
Beyond my knowledge.
Yeah, here's what the statute says right now. Okay, it says, if court finds the plaintiff is entitled to possession of the premises. Okay,
Okay,
tenant is lost.
okay,
The plaintiff shall have judgment for possession. A writ of possession, judgment for possession. A writ of possession shall issue on the date judgment is entered, unless the court orders, and this is Elizabeth's earlier question, unless the court orders for good cause, a stay, okay, but unless they do that, it all happens on the same day. But then it says, the writ shall direct any sheriff to serve the writ on the defendant. And, okay. And not earlier than 14 days after the writ is served, put the plaintiff into possession.
Okay.
So my reading of this means you lose the case, the tenant loses the case. A judgment is issued. The sheriff has to serve the judgment. They don't put them out. They just serve the judgment. And
At least 14
at
days.
least 14 days after they serve the judgment, they put the plaintiff into possession, which means they kick the tenant out. So there is under current law, 14 days. So if
14
we
days.
follow current law, but not the deadlines. So that means we know we'll follow the current law in terms of the process,
Okay.
right?
Yeah.
So we know that when the writ is issued, it's served, boom. So right then when it's issued, which is typical in civil procedure, when court decides the case, you serve it.
Okay.
Okay, so it's served. At that point, the question is, how long, there are two questions, which Joe asserts, I agree, are related to each other. One is, how long should the period be between the moment that I as a tenant get served saying, you're out, buddy, and the moment when the sheriff knocks on my door and says, go. That's one question. The second is, after the landlord says, after the I'm gone, you know, I've been thrown out by the sheriff, how long do I have for the landlord can dispose of my stuff?
Or is it concurrent?
Yeah, or is it concurrent?
That's what I'm wondering, because after
Yes,
going,
that's-
after
I-
circling
yeah.
around, I'm like, the 14 days
20
and
minutes
15
ago, that's
days.
what you asked.
Yeah.
Is it
Yeah.
concurrent?
Yeah,
Don't laugh at
So
us.
actually,
Because I thought it was 29, that's what, so
yeah.
that's.
No, I read it wrong.
Okay,
actually,
Slowly trying to get back to
772,
that.
Sorry.
hey, listen,
I think it'll be
772
Monday.
772 it basically is nothing. It says you lose, you get served.
If you have-
At X days, you're out, and when you're out, the landlord is restored to possession and they can take your stuff.
Be the day 15 right there.
Yeah, right. So if it's 14 days, which is current law, 772 would say that's it, it's over.
So if you
But,
drag it back.
but the sheriff, but there is, it,
No.
because it says at least 14 days, it could be that the sheriff knows of some kind of, like, is it giving the judge a leeway to say,
The
I know
judge
of
has
some
leeway.
extenuating
The
circumstances,
judge,
I can't do it less than 14 days, I can't give you, I can't
the
give,
judge.
I
could-
can't give you, landlord, the ability to, for the sheriff to give only a 1 week.
You're right.
But
The
I
ju-
can give you, tenant, 3 weeks or
Yes.
5 weeks
The
or
judge-
12
It
weeks.
says expressly, the judge can issue a stay. So there's no question that, and this, Elizabeth brought this up, there's no question. Under any of these alternatives, the judge can find that there are extraordinary circumstances, and say, I issued this judgment and the sheriff can't come sooner than 4 weeks.
I asked a question about
Yeah.
that. Say a judge does that, who's paying the rent?
There's, unless there's been an order to pay rent in support, no one's paying the rent.
That's not true, the landlord.
Yeah, the landlords,
So
yeah.
again, the landlord.
It just extends the time the landlord goes without rent, but I don't think that happens very often. That is, no, I don't think the court extends that 14 days very often.
I don't know.
What happens is that sheriffs just don't get around to it. That's the problem. But so
The
going back
notice,
to
the
the question,
serving.
going back to the question. Question 1. How much time shall we give as the minimum time for service of the writ of possession? And that is for, how much time should we give for the
to show
sheriff
up.
before the sheriff throws you out? One version is, the current version is 14 days. 772 says 7. 776 says, and 688, 776 says 5, 688 says 24 hours. So anyway, how long should we give? And then the second is, once they're out, how long do they have to get their stuff? Anybody have an opinion on this?
Is this
That's
real
it.
notice?
Currently, it's 1 day, it's 1 day after the deadline of getting out, right?
And yes. Well, just again, the writ of percent, the wit. Yeah. The writ says that the sheriff
Actually, yeah.
is to remove the defendant and their property no earlier than 14 days after service of the writ.
I'm sorry,
So,
I do not know under current law if it's just from the time the judgment issues to the time that you and your stuff out at the same time? I don't know. I guess we gotta have counsel here. Sorry. But this was good. Everybody knows what the issue
Well,
is.
so I think the current statute makes sense then, because it says 15, the landlord may dispose of any personal property
Because you've got.
remaining in the dwelling or unit without notice or liability to the tenant or owner
Say that.
of the
that he
personal
does
property
On that 14 days.
15 days
experience has
after
been
the
they have
writ
to
of
leave and their
possession is
belongings.
served pursuant to
with
this
them.
chapter.
And if they
So
They don't.
the current
That's one day after, yeah.
Yeah, 15 days after.
Okay, everybody, current law is, current law
I would agree with
is,
that too.
current law is 14 days. The judgment issues. It's served. On day 14, the landlord, excuse me, the sheriff can kick everybody out. And the next day, they can take their stuff. Landlord can take their stuff. That's current law. Now, it doesn't happen. Sheriffs take their sweet time, but still, forget about what the practice is, what the law is. That's the law currently, is 14 plus 1. Okay? 772 is 7 plus 1, essentially 7, and that's it. And 688 is 1 day.
Yeah, and I just want to also point out for the current law, that's taking it to the max.
Yeah.
Like if you leave 2 days after, you now have 12 days to figure out
Get your
getting your
stuff
stuff
out.
back.
That's right.
Because the 15 is regardless
The
of
15,
how long the
yes,
sheriff
right.
is giving
That's
you,
just
could be that the
if you
sheriff
take it
gives
to
you.
the max and the sheriff has to come.
Doesn't make sense though, because the sheriff is at liberty to give you more than 14 days, then
Well,
why would
they
you get
don't
your
give
stuff
you
out by?
more
They don't
15?
give you, they're just not,
They're just
the
not.
law is written that it's no
So-
sooner than. They can show up at any time after.
Yeah, you
Show up
can't,
2 months
you
later.
can't sue the sheriff to make him come out and do it.
So just to,
No, but
because I'm envisioning the other side of getting one of these things. If you've got a single parent who's barely holding on to a part-time job that isn't making its meet, obviously. Somewhere in that 14 days, they've got a day off to scramble and find a place. They're gonna need another day off or weekend day to get their friends to come in and unload the stuff. So I don't, in a lot of circumstances, I can see where 14 days is about the minimum to get stuff out. Because they can't just take time off work necessarily, but then, against the part-time jobs, everything works.
You might have weekends off, or you might have,
You gotta have
Some
a certain
days.
number of days, every so many days of work, you gotta have a certain amount off anyway, so.
So are you arguing for the current situation?
I can see an argument for it.
Joe, what's
I
your
can see
feeling?
where less than that could be really.
Well, considering I finally wrapped my head around the current law about 8 minutes ago, I'm gonna withhold judgment until I have more thought.
Marinated.
Yeah.
Okay, Elizabeth, and then and I think we're out. Yeah,
I urge us not to think about ourselves in that scenario. I urge us to think about people who are, as Tom said, people who are single parents or people with physical disabilities or people who are very old or people who are recently released from the foster care system who don't have like the executive function to be able to pull things together quite so easily, or people who are mentally ill. I urge us to think about people who have enormous blocks preventing them from being able to execute things easily.
Mary?
and at this, the way things are now, 2 weeks is not enough time to find a place. And where are you going to find a place the way the market is now for housing? I mean, if you don't have any family around, if you don't, you're gonna have to go to agencies or you're gonna be out on the street.
Yes?
Causes another problem.
I think the point is that we have to find a balance because all those things are reality, but landlords need to pay their bills as well. So we have to look at it and try to weigh it. What's fair wasn't that the whole objective of this is try to find fairness for landlord and also town tenants.
I think it's to free up rent units that are not on the
Yeah,
market
yeah.
because people are just afraid of getting into a period.
But also, we're talking about the extended periods of time that landlords go without receiving income. And so I feel like if we're looking, like, what is a reasonable timeline? I think that like a realistic, reasonable timeline, even though it's never a reasonable timeline to not be getting money, right? Because it's like going to work for free and not getting paid. You'd be pretty mad if you didn't get a paycheck. So like, but I think that's what we're here to do, is to establish, like, okay, where is the, what is the current statute? What is not working, and how can we address that without causing undue harm?
Okay, yes,
So on page 7 of the side by side projectional actions, the current statute, as it lays out, you're allowed to ask for rent to be paid to the court. And then you as a landlord are allowed to ask the court to disperse those funds if you can prove need. So this is why I'm.
well, what
So-
happens is sometimes landlords do that if they feel like there is any chance that the tenant's gonna pay, but if the tenant's not gonna pay, they're not gonna ask for it.
Well, then it says if the tenant isn't paying the court, then the landlord can immediately take possession. So then why is this
It's not
not a
immediate.
guarantee or a protection against months and months of unpaid rent in a court case?
But you don't pay rent in court for a year.
Until the judge issue.
No, but this is saying you can tell the court, I need this money.
You mean the landlord or
The landlord can tell the court, I need the money.
They have, that's in the current law.
Yeah, so
Why
this is,
doesn't it
so why
happen?
isn't this helping?
That's getting to the point of getting to court. That happens in court, but there's
Yeah.
a lot of time in between there.
I
It doesn't go to court immediately.
think you're asking a good question. I think we ought to get Angela in here to answer it.
And maybe Judge Zone should be back in here at some point, or, we're talking a lot about court stuff, just saying.
Well, I think Judge Zoni is gonna be across the hall. The concern I have is if we never get this out of here, it's not gonna pass this year. I think,
So can I just ask the experienced?
I think we'll ask counsel. And I think I'll ask counsel and ask he can talk to the judiciary. I mean, I think you're asking a good question. I just know this paying rent into court isn't very often satisfactory, but I don't know why. I'm not a landlord.
Because the minute that you don't, the law says that the landlord gets possession.
It's an enforcement issue. So how do we,
No,
I know my feel, sometimes judges like to split the payment of what they owe. Cause it starts from the day, I believe it's the day you make your complaint. Or is it the day of the termination notice? They start back, like how much, yeah, it'd be termination of how much rent do you owe? And the judges will sometimes split that payment. So if they make the first payment. And it's usually like maybe a week later, they have to make the second payment, and then they have to start making payments. Like the first of the month. Yeah, so if they miss any of those payments, you can. Ask for your. Apartment back.
so maybe landlords don't know that they have that recourse.
It's written right,
So,
It doesn't go back to the beginning.
I think it goes to the termination notice.
yeah,
For non-payment of rent, you're talking about non-payment.
Mhm.
Yes, we
It says
certainly.
on H, it says, if the tenant fails to pay rent into the court in the amount and on the dates ordered by the court, the landlord shall be entitled to judgment for immediate possession. The court shall forthwith issue a writ of possession directing the sheriff of the county to serve the writ not earlier than 7 days after the writ is served, or in the case of an eviction brought pursuant to.
Right, yeah.
Yeah, putting the plaintiff into possession.
Yes, we have
That
certainly
we're
treated
mediating
the court
stuff.
system much different than landlords.
Take this stuff, get that stuff out.
You say what?
I said,
So
there's
you're
certainly a
stuck with
different
getting
treatment
their
between
stuff out.
landlord versus the court system. When you don't pay your landlord, you go through this process. When you don't pay the court, you're gone.
Yeah.
Oh, I see what you're saying. Yeah.
I think, but I don't know. Well, I suspect the problem is that this process, whatever it is equally long with the other processes. And the judgment you get is no sooner than you would if you just followed through for non-payment of rent. But why, what causes landlords to do this? I don't know. It may be that, I just don't know. I could see a landlord saying, look, I'm not gonna, this person can't pay rent, they're not gonna pay rent. And so I'm not gonna ask for it because I have to make a motion, gives them a chance if they're represented, it gives their lawyer a chance to oppose it. There's a hearing on the motion, all that costs money, and they're not gonna pay, and then I'll get an ejectment, writ of ejectment, but I'll just go for the writ of ejectment to begin with. But I don't know. We'll just have to find out. All right. It is now 4:00, ladies and gentlemen. I commend you on your. Tomorrow, we start at 9:15, I believe. Is that right?
Yes.
Tomorrow, we start at 9:15, everyone. And we are now adjourned.